Hello, friends. So, good morning to all of you, my dear civil service aspirants. So, friends, कल तक हम लेक्चर्स में डिस्कस कर रहे थे काउंसिल ऑफ मिनिस्टर्स और स्टेट लेजिस्लेचर्स का क्या फंक्शन रहता है और किस तरीके से गवर्नमेंट गवर्न करती है स्टेट लेजिस्लेचर्स में. नाउ टुडे लेक्चर ऑन द टॉपिक ऑफ जुडिशियल सिस्टम इन स्टेट यानी प्रोविंसेस, जिसको हम हाई कोर्ट के नाम से जानते हैं. एपेक्स कोर्ट के बिलो हाई कोर्ट आता है. So friends, before start the lectures, please subscribe, share and like the videos and channels और सब तक ये इन्फॉर्मेशन पहुंचाने की प्रयास करें. So friends, सभी कॉम्पिटिटिव एग्जामिनेशंस के लिए इंडियन पॉलिटी एक इम्पॉर्टेंट फैक्टर रहता है और इस कंपोनेंट से ऑलमोस्ट 10 to 15 क्वेश्चंस आस्क किए जाते हैं प्रिलिमिनरी एग्जामिनेशंस में, चाहे वो पीएससी एग्जामिनेशन सिविल सर्विसेज स्टेट सिविल सर्विसेज हो या फिर यूपीएससी सिविल सर्विसेज का एग्जामिनेशन हो. इंक्लूडिंग अदर कॉम्पिटिटिव एग्जामिनेशन भी इंडियन पॉलिटी के काफ़ी क्वेश्चंस आस्क किए जाते हैं. सो क्लैरिटी के साथ, फैक्ट्स एंड फिगर्स के साथ और एनालिटिकली अप्रोच के साथ हम इस लेक्चर्स को डिस्कस करते हैं और यहाँ पर आपके सामने इस लेक्चर्स को एवरी डे वन बाय वन डिस्कस कर रहे हैं. सो फ्रेंड्स, हाई कोर्ट इज द बिलो ऑफ द अपेक्स कोर्ट जो स्टेट में फंक्शन करता है. हर स्टेट का अपना अपना हाई कोर्ट होता है और कई स्टेट्स ऐसी हैं जिनका जॉइंट हाई कोर्ट भी होता है, जिस तरीके और कई यूटी ऐसी हैं जिनका जॉइंट हाई कोर्ट होता है. जैसे अभी नई यूटी बनी है जम्मू कश्मीर एंड लद्दाख, बट इनका हाई कोर्ट जॉइंट है. और कई स्टेट ऐसी हैं जिनका, जैसे चंडीगढ़ यूटी एंड पंजाब, जिनका हाई कोर्ट सिमिलर है. इसी तरीके से इंडियन सिंगल इंटीग्रेटेड सिस्टम में जो है हाई कोर्ट ऑपरेट करता है बिलो द सुप्रीम कोर्ट बट अबव द सबऑर्डिनेट कोर्ट होता है ये. और जुडिशरी इन ए स्टेट कंसिस्ट करती है हाई कोर्ट को एंड हायरार्की ऑफ सबऑर्डिनेट कोर्ट को. हाई कोर्ट ऑक्युपाइज करता है टॉप पोजीशंस इन द जुडिशियल एडमिनिस्ट्रेशंस ऑफ ए स्टेट. The institutions of High Court originated in India in first time 1862 during the colonizations of British government. When the High Courts were set up, फर्स्ट हाई कोर्ट जब सेटअप हुआ था एट कोलकाता में, मुंबई में एंड मेड्रास. 3 प्रेसिडेंसी सिटी थी, कलकत्ता, बॉम्बे एंड मेड्रास. 1862 में फर्स्ट हाई कोर्ट कलकत्ता एंड बॉम्बे एंड मेड्रास बना. 1866 में ए फोर्थ हाई कोर्ट वाज एस्टैब्लिश्ड एट इलाहाबाद एंड इन द कोर्स ऑफ टाइम each province in British India came to have its own high court. After 1950, a high court existence in province became the high court for the corresponding state. Constitution of India ने प्रोवाइड्स किया है हाई कोर्ट जो है हर स्टेट के लिए. बट 7th अमेंडमेंट एक्ट 1956 ऑथोराइज्ड करता है पार्लियामेंट को कॉमन हाई कोर्ट एस्टैब्लिश किया जाए टू आर मोर स्टेट और फॉर 2 or more states एंड ए यूनियन टेरिटरी. ये कॉन्स्टिट्यूशन ऑथोराइज्ड करता है पार्लियामेंट को. टेरिटोरियल जुरिस्डिक्शन हाई कोर्ट की जो है वो को टर्मिनस होती हैं विद द टेरिटरी ऑफ ए स्टेट. सिमिलरली, टेरिटोरियल जुरिस्डिक्शन ऑफ ए कॉमन हाई कोर्ट इज ए को टर्मिनस विद द टेरिटरीज ऑफ द कंसर्न स्टेट्स एंड यूनियन टेरिटरी. एट प्रेजेंट वी हैव 24 high court in the country. One out of them, 3 are common high courts. 4 are common high courts. पहले 3 common high courts थे, अब 4 common high court हुए हैं क्योंकि एक नया हाई कोर्ट कॉमन बन गया नई यूनियन टेरिटरी का एस्टैब्लिशमेंट होने से। और वो नई यूनियन टेरिटरी कौन सी है? जम्मू कश्मीर एंड लद्दाख। इनका ज्वाइंट हाई कोर्ट है, कॉमन हाई कोर्ट जिसको हम कहते हैं। दिल्ली इज द ओनली यूनियन टेरिटरी that has a high court of its own since 1966. The other union territories fall under the jurisdiction of different state high courts. The parliament can extend the jurisdiction of a high court to any union territory or exclude the jurisdiction of the high court from any union territory. The name, year of establishment, territorial jurisdictions, and seat with benches of all the 24 high courts are mentioned in these chapters. So, under which article we can say the high court falls? So, the constitutions provides article 214 to article 231 in part 6 of the constitutions deal with the organizations, independence, jurisdiction, powers, procedures, and so on of high courts. Organizations of high courts, every high court, whether exclusive or common, consists of a chief justice and such other judges as the president may from time to time deem necessary to appoint. So this way, the constitution does not specify the strength of a high court and leaves it to the discretion of the president. Means it is the discretionary power of the president how much strength have to be kept in the high court or have to be appointed in the high courts. That is depend on the discretionary power of the president. It is not mentioned originally in the constitutions. Accordingly, the president determines the strength of the high court from time to time depending upon its workload. Depending on its workload. Unnecessary, the strength is not can be determined. The strength cannot be determined by the president in the high court which has no workload in the high courts. That's why it is the discretionary power of the president. Now judges, how the judges appointment can be made in the high court? The judges of a high court are appointed by the president. The chief justice is also appointed by the president, but after consultation with the chief justice of India. The chief justice of high court is also appointed by the president of India, but after consultation with the chief justice of India and the governor of the state concerned, for which state the chief justice have to be appointed, consult with the chief justice of India and with the consultation of the governor of the concerned state where the chief justice of high court have to appoint. India and governor of the state concerned. For appointment of other judges, chief justice of the concerned high court is also consulted in case of a common high court for two or more states. In case of common high court of for two or more states, the governor of all the states concerned are consulted by the president. The governors of all the states are consulted by the president. So this is the difference between common high courts appointment judges and the single high court appointment judges. In second case, in 1993, the Supreme Court ruled that no appointment of a judge of the High Court can be made unless it is in conformity with the opinion of the Chief Justice of India. In the third case, 1998, Supreme Court opined that in case of the appointment of chief justice, in case of the appointment of high court judges, the chief justice of India and consult a collegium of two very senior judges of the Supreme Court. Without their consultations, without their consultation, the judge's appointment cannot be made a valid. In this way, the sole opinion of the Chief Justice of India alone does not constitute the consultation process. Now, the qualifications of judges, the parameters have to be set up in the constitutions of India. To qualify the judges, those person to be appointed as a judge of a high court should have the following qualifications. So, which qualifications? First, number one, he should be a citizen of India. Second, he should have held a judicial office in the territory of India for 10 years, or he should have been an advocate of a high court or high court in successions for 10 years. So these three criteria for the qualifications of the judges of the high court. Without judicial office in the territory of India for 10 years, no persons can be appointed on the chairs of the judge of a high court. From the above, it is clear that the Constitution has not prescribed a minimum age for appointment as a judge of a high court. Moreover, unlike in the case of a Supreme Court, the Constitution makes no provision for appointment of distinguished jurist as a judge of a high court. Oath and affirmation must be made for the appointment of the judge of the Supreme Court, High Court. A person appointed as a judge of a high court before entering upon his or her office has to make and subscribe an oath or affirmation before the governor of the state or some person appointed by him or her for this purpose. In his or her oath, a judge of a high court swears. What swears? First, he or she a bear true faith and allegiance to the constitutions of India. Second, to uphold the sovereignty and integrity of India. Third, to duly and faithfully and to the best of his or her ability and knowledge and judgment performs the duties of the office without fear or favor, affection or ill will. And the last, to uphold the constitution and the laws. These are the four criteria points the person before entering upon the office swears on the stage before the governors. Now the how much time the judges are staying in the post of the high court judge. So tenure of the judges. Constitutions has not fixed the tenure of a judge of a high court, but however, it makes the following four provisions in this regard. So what provisions? These four provisions are most important, and many objective types question in the statement wise can be asked in the preliminary examinations. Number first point is he or she holds office until he or she attains the age of 62 years. This is the criteria. Until the age of 62 years, the person can be remain as a judge of the high court. Any question regarding his or her age is to be decided by the President after consultation with the Chief Justice of India, and the decision of the President is final. Nobody can challenge the decisions of the President in any courts or any judicial system in the country. The decisions of President is final and unchallengeable. Number second point, he or she can resign his or her office by writing to the President. In fact, the judge of the High Court can be appointed with the consultations of Chief Justice of India and with the consultation with the governor of the concerned state by the President. But when the judges want to given the resignations, he can submit his resignation letter to the President of India, not in the governor and not present to the Chief Justice of India. Number third point, he or she can be removed from his or her office by the President on the recommendation of the Parliament. Without recommendation of the Parliament, no judge can be removed from their post. This is the power of the democracy, and this is the power of the parliament in democratic system or democratic institutions in our country. Number fourth point, he or she vacates his or her office when he or she is appointed as a judge of the Supreme Court, or when he or she is transferred to another high court. Then the office can be remains vacant. So these are the four provisions in this regard. The tenure of the judges can be decided by the President of India, and the decisions of the President is final, and decision of the President, not single decisions of the President. Before taking the decisions, the President consult with the Chief Justice of India about the tenure of the judges of the High Court. So if the judges are not perfect or removed, or have to be removed from the post of the judges in High Court, then what is the process? Removal process. We can say removal process, removal of judges. A judge of a High Court can be removed from his or her office by an order of the President, not by the Governor or Chief Justice of India, only by the order of the President. The President can issue the removal order only after an address by the Parliament has been presented to him or her in the same session for such removal. The address must be supported by a special majority of each House of Parliament. That is, what is special majority? That is a majority of the total membership of that house and majority of not less than two-thirds of the members of the house present and voting. That is a special majority. The grounds of removal. On what grounds the judge have to be removed? Without the ground, the judge cannot be removed. The ground of the removal are two. Number one, proved misbehavior or incapacity. 2 points. Prove misbehavior, proved misbehavior or incapacity. Thus, a judge of a high court can be removed in the same manner and on the same grounds as a judge of the Supreme Court. The Judges Enquiry Act 1968 regulates the procedures relating to the removal of a judge of a high court by the process of impeachment. But impeachment can be imposed to remove the president from the post of the president. Mostly, the removing impeachment word can be used for the removal of the president and not for the judges. For judges, remove words can be used. So removal motion signed by 100 members in case of the Lok Sabha or 50 members in case of Rajya Sabha is to be given to the speaker or the chairman of Rajya Sabha. The speaker or chairman, speaker of Lok Sabha and chairman of Rajya Sabha may admit the motion or refuse to admit it. That is depend on the decisions of the speaker or chairman. If it is admitted, then the speaker and the chairman is to constitute a three-member committee to investigate into the charges. Not without investigation, the decision can be made by the speaker or chairman finally. Before taking the decisions, the speakers or chairman constitute a three-member committee to investigate into the charges that charges are imposed against the judge for the removal to him or her for the post of from the post of the judge of High Court. So the committee should consist of the Chief Justice or judges of the Supreme Court and Chief Justice of a High Court and distinguished jurist. If the committee finds the judges to be guilty of misbehavior or suffering from an incapacity, then the House can take up the consideration of the motion. After the motion is passed by each house, a parliament by special majority, an address is presented to the president for removal of the judge. Finally, the president passes an order removing the judge. So, in this way, in this process, the judge of the high courts can be removed by the order passed by the president. So, friends, now the lecture is over. Tomorrow we will discuss about the salaries and allowances of the judges of the high courts, and सब्सक्राइब शेयर एंड लाइक द चैनल्स एंड वीडियोस एंड सब तक ये इंफॉर्मेशन पहुंचाएं एंड wish you very all the best and try to gain the all informations in these lectures with clarity and to prepare very well for the incoming preliminary examinations and including main point of view. So friends, thank you so much and Jai Hind.